Hello, everyone. It's Christy. Sorry, I didn't hit the button. It's very tiny. Welcome to a chat which should have taken place 2 weeks ago, but because of various technological and time zone complications, is finally taking place tonight, and I'm very excited. So I'd like to welcome MarkusDrake to my channel. Thank you for your patience and also for showing up this evening or afternoon. We're in the timeline you are.
Yeah, afternoon in the East Coast of the U.S. But yeah, no, thank you for having me. I'm absolutely always happy to talk about law. So, you know,
I have a feeling that in a different life, if I would have not picked politics, I think I could have made a halfway decent lawyer because I've got a fairly good memory for things. And I like boring minutiae. Like court procedure and procedures. I think I probably would have swum those waters with ease.
yeah,
Uh,
the high tolerance for boring minutia is actually a unfortunately relevant skill.
well, it comes in handy
That
when I have to write papers and do my own references. So,
yes, I was going to say that and a willingness to obsessively research, which
yeah.
you're an academic. I'm sure that's already fine for
Yeah,
you.
you always got to do the Google Scholar. Got to be checking
Yeah,
what's the newest thing. But yeah, so
absolutely.
we were going to discuss. Oh, you know what? I put the picture up and then I realized that actually it won't change between us because there's just the you. So I'll do some editing on the fly here. It's fine. But why
Okay.
don't you, yeah, we're talking about Trump's basically disqualification from the Colorado Supreme, based on a Colorado Supreme Court decision that he actually meets the criteria as laid out in Section 3 of the 14th Amendment, that of having engaged in rebellion or insurrection or given aid or comfort thereto. I don't remember if they were particular on which if it was like both. Well, I know I think they did the insurrection part for sure. But yeah, and then it was appealed to the Supreme Court, and nobody really knows what the Supreme Court's going to do. So I thought we'd talk a little bit
Yeah.
about that and some of the questions that might or might not come up, because the court it's a court of appeals. It's not a fact-finding court.
Indeed.
I think unless a state is a party to a, 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 a lawsuit, it is not the court of first, jurisdiction or however that's phrased. And is that right?
There's a couple of other small ones,
Okay, yeah.
but yeah, principally that's going to be the case.
Yes. So, all right. Now we got both Lion Kitty and you on the screen. It's going to kind of cover up
Fantastic.
the uh, a lava lamp a little bit, but I can maybe take that and kind of scooch a couple things here. So let's talk a little bit about. Well, I guess where do you want to start? Do you want to start with the Civil War? Um, because clearly, that was the time frame in which this was set up, and
Yeah,
but the authors of the amendment were quite clear it was meant to go forward in time. And the other thing that kind of doesn't often get mentioned, in my opinion, when this case is brought up, is the fact that they have included a remedy for this disqualification in the Constitution, in the amendment itself, which is your defect can be removed by 2/3 votes of both houses of Congress.
a remedy that has been previously exercised, so it's not just theoretical.
Right.
Yes.
Okay. Okay. So that's something I didn't know. So let's go back. Yeah. Let's start with some of the history because how I've heard that waivers were given to former rebels. Wasn't
Hmm.
the vice president of the Confederacy eventually a member of Congress and in the House? Anyway, but yeah, tell us about that because that's fascinating to me.
Sure. Yeah. Not being a historian, I'll do my best. But
Yeah.
yeah, so after the Civil War, you get these three Reconstruction amendments: the 13th banning slavery, the 14th with the Equal Protection Clause, Due Process Clause, and then the 15th, which says you can't deny the right to vote for, among other things, past conditions of servitude. Basically, trying to stop things like grandfathering clauses.
Right.
Um, Most of these provisions are seen as being self executing. You don't need any additional legislation, though you absolutely can if you're so inclined to pass them. Um, and in the spirit of reconciliation, therefore, since it was seen that they took effect immediately, most of the there was like a general amnesty for most of the rank and file Confederates.
Yeah, they didn't
Not
prosecute. They didn't
Hmm?
send every single rebel through court to get a conviction for insurrection, did they?
No, they did
You
not.
know, that wouldn't be practical.
Yes. It wasn't going to be practical. And for some of the higher ranking ones, there was a fear that, well, A, it would turn into something of a circus, but also B, you might accidentally legitimize the concept of secession.
Well,
Um,
over heavy-handed tactics
yeah.
kind of thing. All right.
Well, yes, but also, we ended up getting a Supreme Court decision in the 1860s called Texas v. White that
I know,
ruled
I
that,
heard about this one. That was
yes,
the case that went directly to the Supreme Court because the case state was a party to the case, right?
yes, indeed.
Yeah. Okay. That's what I remember from like 2 days ago on the news. See, I could have been a
Yeah.
good liar. All right. Anyway.
Yes,
Oh, and can I tell you
um,
so I know that the basic premise of the case is a company came in and sold bonds. I think it was when Texas was still a confederacy. It has something to do with the sale of bonds and the state of Texas, and when it became the contract was done when they were a Confederate state, and then later on the company tried to claim it back later, and it went to the Supreme Court because Texas under the Constitution wouldn't pay, and the Supreme Court said, "Look, the Confederacy was illegal. The contract was illegal. It never happened."
yeah, more or less.
Yay!
Yeah. So they did eventually end up having whether or not you can secede dealt with.
Mm.
And I will say, for the sake of Clarence Thomas, who I presume is listening,
Always. He's
yes,
checking out all the podcasts.
that was the view of the founders. I'm not going to get the quote exactly right, but Madison did say that a ratification of, or the ability to leave the Union would be as ineffective as a ratification of only part of the Constitution. You take it all permanently or nothing. And he was the architect of our Constitution. So clearly
Correct.
this is some long-standing idea.
This is a very originalist reading.
Indeed. And so we do eventually have Texas v. White. We do deal with that. But basically the concern was, especially since jury nullification was a lot stronger in our history, that if you put someone like Stevens or Lee on trial, one, you just have the technical thing of where do you try them, right? Which court has jurisdiction?
Okay.
And then you have the issue of, well, what if they're acquitted?
Yeah. Yeah. What if the juries could be anybody, right? So
Yeah. So you might
get a bunch of Southern Confederate boys down there. And he's like, I'm not convicting my general.
Yeah.
Kind of thing.
You're going to try General Lee in Richmond? Because I feel like that won't go well.
Yeah. Change of venue.
Yeah. So a couple of them had certain levels of punishment. I do believe General Lee effectively agreed to some level of parole, although the president and vice president, I don't think ever were prosecuted.
No.
But the vast majority of Confederates, yes, received a reprieve for their inability to hold office. I think it was actually the first. No, it was not the first general pardon that would have been issued. Technically not a pardon, but functional equivalent. But it wasn't the first one.
Okay.
In any case, before I get too lost down my own tangent. So the fact that we have this built-in system does indicate, at least to me, that if Congress has to go and affirmatively remove the disability, which is the term used, then it's presumed to apply at the moment of the infraction.
Yeah, because if the argument being made is that there needs to be a conviction for insurrection, but it doesn't say it won't overturn a conviction. It says it will remove the disability.
Yes.
Okay.
Which is interesting. We'll see if they actually try and address it on appeal. Trump's brief presented a very, very large question that I'm sure the Supreme Court is not happy about.
Yeah, there wasn't the question to be answered is, did Colorado err in disqualifying Trump from the ballot, which sounds like an essay you'd write for an undergraduate law class, not
Yeah.
a question an issue of constitutionality that you'd hand the Supreme Court.
It's also because I have read it. It is a shockingly short Supreme Court brief, but they'll probably supplement it. I have to hope.
I love the fact that they wait for the very last point to go. And oh, by the way, yeah, he didn't do the insurrection. Just okay, out. Like that was their fifth point, not their opening point.
Yes. Yes. Yeah. So they do bring up, I think, all 5 points that were addressed in the Colorado decision. They even brought up the idea that Colorado election laws were inapplicable to this proceeding, sort of a potential due process violation, which I don't know if you read any of the dissents.
I read the first
camera.
I read the first one, but I didn't get, and then I didn't read the other one or the other two, whatever. Yeah, so it was only the first one I read. It was mostly procedural.
Yeah,
it was
that was the complaint.
The complaint was the law says it has to be within 5 days, and we didn't really do it, or whatever period of time. And we held a meeting that was to delay the meeting, but that really wasn't processing it within 5 days. But also we can't do within 5 days because it's much too large a question. So either way, I guess we have to put an insurrectionist on the ballot in Colorado because, I mean, that was kind of the conclusion that I felt like it was coming to, which is we can't deal with this. Like we have no remedy for insurrection because of the way that the administrative code or whatever law is written.
Well, I'll make a slight defense of that Supreme Court justice, because this is often the case when you kick things like this for procedural reasons.
Yeah.
Essentially, they're just saying, you could sue other entities, you could sue via normal procedures. You're suing under a very specific part of our code that allows for expedited review. And basically you're saying you don't deserve expedited review. Go about it the long way like everyone else.
But okay, can I intervene here and ask, is Colorado's the procedural the process, which the court looked at and the majority said we can handle this, and it might take a little bit longer, but then again, we're supposed to also have speedy trials in this country. So, although that's a less precise metric, but if it was okay, Colorado should have had the hearing in the 5-day span or whatever window was allowed under the statutory regulations. That doesn't deal with the main question. And well, okay, I guess there are two questions. One is, can the Supreme Court go in and say Colorado has a defect in its process and therefore we have to throw it out? How is that in any way constitutionally related?
Well, the claim being made by Trump. Okay, let me first just answer straight up your question. Yes, they can.
Okay.
As with the all standard qualifications that I'm sure you can imagine, I'm screaming in my head.
Sure.
Because there is a concept of sufficient state grounds that the Supreme Court won't is very deferential to state Supreme Courts because they're interpreting their own law. However, in this case, Trump is alleging potentially that the Colorado statute violates his protections under the federal constitution.
Under due process.
It's framed like a due process.
Yeah,
but technically they say it's the electors clause. I don't know why.
Okay.
But I'm just going to treat it as a due process claim for purposes of conversation.
All right. I think it's a more common framework for people. So
yes,
we'll just kind of substitute due process for electoral claims due process, some sort of But this due process claim is built on an implicit assumption that that disqualification isn't self-executing, isn't it?
Well, that's actually interesting. So that is definitely the argument they're making. I'm not sure if you would need to make that argument. You could make the argument that, even if it's self-executing, and even if Trump is ineligible, Well, technically, there's two arguments they make. One is that Section 3 only prevents you from holding office, not from running for office, which, frankly, I think is ridiculous.
And also,
Um,
didn't California and Colorado both remove people from the ballot because they were ineligible to hold office?
yes, like
Okay.
this is a thing that's happened before.
Yeah.
It's very weird. We've removed people who were in office and people running for office multiple times.
Yes.
Um,
This isn't a new thing. Wasn't like just suddenly applied to Trump. These things have been happening, chugging along at local levels and state levels since, for a while. Since
yeah,
qualifications were a thing, I'm sure.
but technically, this hasn't been ruled on by the Supreme Court before,
Yeah.
so they can say basically, "Hey, all those lower courts got it wrong." I don't
True.
really buy it,
Yeah.
but okay, that's the argument they could make. The other one you would make is to say, well, look, maybe I shouldn't be on the ballot, but the Colorado Supreme Court, not Supreme Court, Secretary of State put me on the ballot. And so any like further proceedings, further litigation to change the status quo should still be done constitutionally. Sort of, look, this is a box we cannot put the genie back in, except but through the proper means, and that involves full due process, right?
But that would only apply to the primary election.
Yeah, most of these are essentially proxy fights for the general, which I actually am kind of supportive of because I don't want another Bush v. Gore situation where we're breathing down the neck of the Electoral College.
Yeah, please.
Yeah. And unfortunately, we have seen, like, I think it was the Michigan Supreme Court did defer on ruling on this issue because they said, well, it's the primary. The GOP is a private organization, under their right of freedom of association. They can.
Oh, is that how they ducked it? Oh, that's good.
Yeah.
Oh, that's good.
Yeah.
Okay. Because it just looks to me like the courts have seen I honestly think there's intimidation is playing a factor in some of this hot potato, or letting him on the ballot when he clearly, in my opinion, of course, meets the thresholds for disqualification. But yes, so getting back to your point.
But yeah, so there have definitely been some states that have said, well, look, we're only going to address this when it comes to the general. It's not ideal. I'm glad we are addressing it now. I will note, towards your point, with judges, I always think, not always, in the vast majority of cases, they're human, but they aren't generally complete hacks.
No, I think this is a unique situation. I mean, we've seen what happened to Ngoron, for instance.
Yes.
What's happened to Judge Chutkan. And these things, I'm sure, are discussed around the water cooler.
Yes. And, judges tend to be very good at reasoning themselves into a position they already hold. Right? So maybe, if you look at someone like Alito, he doesn't care at all. But Roberts, to steal a phrase from Ali Maistel, is really good at creating a world that doesn't exist and living in it.
Yes.
You're essentially dealing with the 9 greatest rationalizers in the country when you're before the Supreme Court. So, and that applies to the lower courts as well, unfortunately.
So on the bigger question of can the Supreme Court decide Colorado didn't follow a proper procedure and therefore Trump's eligible to be on the primary ballot? This again, was there more? Because I want to make sure we don't get too far afield and we stay focused. So more on that.
Basically, I see no reason why they would not be able to. They may choose not to, just as a matter of tactics. But even then, it would be, we're vacating that decision and remanding for you to do it again, but properly this time.
But then they would also have to kind of, so do it properly. Well, I mean, do it within the time frame. I guess they've already heard it once, right? They've already, Colorado Supreme Court's already taken in the congressional testimony and evidence, and they've had both parties make arguments over 2 weeks or whatever it was. So it would probably just be a repeat on fast forward of what happened before. And then that would mean that states, but I mean, if that was the only thing they ruled on in isolation, that would mean that it is up to the states to decide whether or not a president can be on the ballot, and we could have a patchwork of elections where Trump is and is not on the ballot.
Well, if that's where the case dies, so if the Supreme Court remands it and says do it again but properly this time, you've got a couple options. The Colorado Supreme Court could look at the text of the decision and say, okay, well, everything the court wants us to change are merely questions of law. The record is sufficient as is. We can review this again under their new standard. Or they might say, okay, well, we need further proceedings. This has to go back to the trial court to do X, Y, and Z extra things.
Okay.
And then once either of those happens, people can appeal again and appeal right back up to the Supreme Court. And it's happened more than once. I think the most times I've ever seen a case go to the Supreme Court is 3.
Wow.
So it's not super common, but it is possible. And especially if they try and kick it on merely procedural grounds and give no substantive instruction, I expect that people will be back. This is too large an issue for them to duck entirely.
In one decision. Yeah.
Yeah.
Okay. All right. So that's the piece about the Colorado process. I did have our Discord conversation up, and then I like a silly goose. All right. So.
Oh, nice.
Yeah. And they're not taking up the main decision, or at least they haven't yet. Is that because they?
No. So what happened in Maine, unless there's been news within the last couple weeks, the Maine Supreme Court declined unanimously to hear any appeal from their Secretary of State's decision until the Colorado case is decided.
Okay. All right. So they kicked it into the long grass too.
Basically.
All right.
Again, I wish they'd heard it because it's the same thing. I think like, well, there are still state questions here about your procedure, the powers of your Secretary of State. You could absolutely rule on all of those. And also, you can still do your own independent analysis of the federal question because the court can always conjoin the two cases sua sponte, and now it has...
Okay, you have to translate that. Join the cases. Yeah.
Sua sponte basically meaning on its own prompting. So no one requests it, just the court goes, oh, this is better for efficiency if we hear these cases with the exact same problem together.
Got it.
Yeah. Which they do all the time. So it wouldn't be particularly unusual. But then instead of looking at, 4 decisions, right, the Colorado one and the dissents, they would also say, well, we also could, maybe we want to adopt the analysis of one of the main concurrences or whatever, right? It would just give more options.
Okay.
But judges are skittish creatures that tend to flee from loud noises. So I'm not surprised.
Okay. So I think because this is such an interesting conversation, it's so interesting to listen to you. We were going to talk initially about examples where former insurrectionists had been given the removal of the disability with the 2/3 votes of Congress. And you alluded to that. And then we started talking about the Civil War. And then we got onto this. So I wanted to come back to that because there's precedent. People who had been previously disqualified were given the okay and later served. Is that the impression? That's kind of the impression I got from you.
That is my understanding. Because it's an act of Congress rather than an act of the courts, I have to confess I'm not as familiar with that, other than just learning that it happened and that it was occasionally referenced by courts in the 1870s. The last time this was actually relevant.
Right. Yeah. It's been a minute. Give or take a century or a century and a half. Okay.
But I will say, cut me off if you don't think this is a relevant point. Um, I actually found quite interesting, speaking of the main decision. So we saw two challenges under the
Hmm.
14th Amendment, but there was also a challenge under the 22nd Amendment.
Under
Um,
the mental competence? What is that one?
that's 25th.
Ah, okay. What's the 22nd?
22nd is the Roosevelt Amendment. Basically, it's the two terms one.
It's calling Trump's bluff.
Yeah, basically. And, of course, they sort of laughed at the guy and went, okay, yes, we get the joke. Very funny.
Yeah.
Please leave us alone.
Yeah.
But it did actually raise kind of an interesting thing for me. And I think this is probably a good example of how appellate law actually forms when you do get a vaguely plausible case, which is the 22nd Amendment says that you cannot be elected to the office of the presidency more than twice, generally, right?
Okay.
So if they were to take that guy's challenge seriously, they would essentially have to ask the Trump lawyer, when he says he won the election, exactly at what point does a president become elected?
Yep.
Because it has nothing to do about serving in office.
No. Yeah.
So you've got, at least as well as fair as I've been able to ID, and I have had this fight with some of my coworkers because I think this is fascinating. There's up to 4 potential points at which you can claim someone's been elected under the U.S. system.
Okay, let's hear.
Which is 1, on election day when the actual votes are cast and collected. You could basically, I'll go through them. You could then say perhaps when a sufficient number of states have certified their elections, which normally happens a couple days or weeks later. You could say when the Electoral College votes, which is normally in December, or you could say when the Electoral College vote is certified under the 12th Amendment, which last time around was January 6th.
Correct.
So, well, first I'll ask you, I guess, which would you consider like, okay, that's the official one. This person is now been elected president.
Well, I do political behavior, so this kind of skews me. I think that the election itself, the voters' final totals, and if there's a recount, that final total, is the basis of the rest of it, which is just process. So I think you win on election night, and then the rest of it is the legal instantiation, let's say, of that power that you get. That would be my take. Where you fall?
Good. I would say when the Electoral College votes.
Okay, because you're right. In the Constitution, it does say the electors. Although, yeah, they don't really talk about the They talk about the electors, don't they? In the Constitution, that's
and technically
true.
on election day, you're voting by name for the president, but you're voting for their electors.
Yes, and those electors can vote for, technically, unless they're bound by state law, whomever they want. Yeah. So they're casting the final votes.
Yeah. The term for that is a faithless elector, right? And to my knowledge, even when states have prohibitions against faithless electors, the actual vote is still valid.
Free speech.
The elector could be punished afterwards.
You do the crime, then you do the time. But okay. But your vote still
like
counts.
My favorite faithless elector was in 2004. I think he was from Massachusetts. A guy was an accidental faithless elector because he voted for John Kerry, but he spelled John incorrectly. Right? Ended up not mattering in that election. But yeah, I would say because they have the power to change the outcome of the popular vote, that is where I would say it sort of seals it. And then I would describe the certification process as merely ceremonial. But
well, I think you can look at it from a democracy point of view, and you can look at it from a constitutional point of view, and both can be valid because they're using different frameworks.
Yeah. So I think it is that sort of like weird stuff, which I think is probably part of the reason why, unfortunately, I find that reporting on the technicalities of the law tends not to be that great.
Yeah.
Because what you can get then is a decision that basically, would come down and say, oh, Trump's been disqualified under the 22nd Amendment. And what you really had was people arguing over whether or not it should be the election day or,
Mhm.
Jan 6 or something like that. And again, like I said, judges aren't blind. You can definitely reason your way to whatever you want so that you get the outcome you want. But sometimes it can definitely be a little bit more rarefied, I suppose. Pretentious, if you want to be more honest.
So do you think that it will be tolerable to the Supreme Court? I guess they don't always have to like their decisions, but this idea of a patchwork of eligibilities? I mean, the power to conduct elections is left to the states.
It is.
And therefore, yeah, so, if we have a patchwork of lots of things, why not presidential qualifications if that's how the states are organized?
I think that's probably not unreasonable. And it may be that way going forward. Part of the reason why I'm skeptical that would be the outcome in this case, even though the conservative judges do prefer more state empowerment
Mm-hmm.
over, time, place, and manner of elections, is because this is a case of first impression, technically, right? They've never
Right.
ruled on the definition of some of these terms before or how they're supposed to function.
Mm-hmm.
And so there's always the possibility that by defining these terms within this specific context, they don't really have a choice but to rule on how it would apply in this specific instance and settle that case or controversy before them. So if they want to define what it means to have engaged in an insurrection, they want to define if Trump's speech violated Brandenburg v. Ohio, current standard for free speech. I think they'll have to effectively decide this case, if nothing else.
No, but if they were to interpret the meaning of what it means to engage in an insurrection, that also extends to giving aid or comfort, which is
It
also
does.
part of the, yes. So it encompasses a wide range. It's not merely picking up a pitchfork and walking to the state capitol. Giving aid or comfort. I think that was not really dealt with. Everyone was more focused on the idea of engagement in something and in what an insurrection was. And a lot of the Colorado focus seemed to be on that part, but not on the aid or comfort. So I'm just kind of wondering, they can't really, I don't see the use of doing the one without doing the rest.
I guess, because I think that's the thing, right? My understanding, as I recall, from the Colorado Supreme Court decision was, you're right, they only really talked about him engaging in the insurrection.
Mm-hmm.
If the court wanted to half punt, they could say, hey, here's what it means to engage in an insurrection, and Trump does not fit that bill. Therefore, we have to vacate the results of the Colorado opinion and kick it back for further proceedings consistent with this opinion, which would probably be putting it back on the ballot. They could then duck and say, look, we weren't asked to decide what it meant to give aid or comfort, or
Yeah.
if Trump's conduct was that. You asked us one question, we answered it, go away.
Yeah.
That might be a decent way for them to sort of try
Dodge.
and get around that
Mm-hmm.
issue.
Yeah. What do you think it is the likelihood that they're going to, provide a legal framework for what it means to engage in an insurrection or rebellion? Just that first part that they were asked to. Like, is that something that you think that they will? That's going to be the big part of what they're going to end up discussing in their opinions.
I don't really see. Well, I guess that's kind of the issue. I don't know, and it's only because I don't know if they're going to take the exit ramp
Mm-hmm.
or one of the big ones is whether or not the president is an officer under the United States.
Yeah, that one to me seems pretty self-evident. I think they could probably rule on that pretty quickly and just say yes. That
Yeah.
was also the intention of the authors. You know, we have the transcripts from the debate in the Senate, and one of the senators says, "How come the president and vice president is on there?" And the other guy goes, "Oh well, the gentleman surely would understand that office is, counts in that." And they go, "Okay, I'm sure you're right. I'm sure it does." So we know they had that discussion. So I think of all of the things that they have to deal with, declaring the presidency in office is and the president officer is the easiest one. But am I wrong?
Well, I mean, I agree with you, but I
Okay.
will say, technically, the argument they're making is either he's not an officer or he's not under the United States. That the presidency is like a fundamental constituent part of the United States government, not merely someone subject to it.
Right. But he's also the commander in chief of the military, which would make him the highest military office in the land, right?
That's true.
And
I
that's
guess you
definitely
would.
an office of the under the United States Constitution. So, military. So
Yeah, I wonder if they would say, well, these are separate roles the president's acting in, right? One is the political, the administrative,
mhm.
separate from his wartime duties.
But as
That,
that officer, he would have taken an oath to uphold the Constitution in that capacity.
oh yes,
Even if he didn't
yeah.
do it as president, you can't really divide, like it's the baby as in per Solomon. They're kind of
Yes.
they're one and the same. Even if they have different hats, it's still the same person making the oath. Would be my counter,
Yeah,
point.
yeah, and he does just swear the one oath,
Mhm.
one that I think is actually more binding than the one that's used for like congressmen and senators.
Yeah, and
Um,
I didn't say support. I never said support.
yeah, but yeah, it gives about three different. Well, the Colorado Supreme Court dealt with that pretty well. They were like, yeah, it gives three different words, all of which include in their definitions and synonyms the word support. I don't know what you want here, dude.
What are the chances that they're going to say, "Look, Mr. Trump, there's a remedy in the Constitution. You can go to Congress to
I
remove
think
this."
virtually none. I think that would be the sort of principled conservative
I mean,
position.
isn't that the originalist position? Because that's what happened, right? That's how it functioned in the past.
I think that would be more the textualist position.
Okay.
So if anyone's going to go for that, it would be Gorsuch.
Mm.
I think he's the most principled textualist on the bench. Barrett and Thomas, I don't think would buy that. Because yeah, otherwise you'd essentially go like, look, well, I'm looking within the four corners of the section. Here's a disability. Here's the qualification for it. Here's
Yep.
the remedy for it.
Yeah.
I don't understand what you want from us.
I would love that to be the decision. That's it.
I mean, it basically would be if I wrote it, but
Yeah, yeah.
no one asked me to write it yet. But yeah, so I mean, the originalist position, it depends, right? Because you can get multiple different things that people will point to for originalism. Some will try and say the original intent of the actual drafters.
Yeah.
But the other, I think, probably more common and closer to Thomas is the words as they were understood widely by the public at the time of enactment.
Right. The obvious meaning, the prima facie meaning of the contemporary authors.
Well, not even the authors, the listeners.
Right. Okay. Yes. Yeah. The whole country,
Yeah.
or people.
So, for example, you could reliably say under that justification, well, look, yeah, you got one representative somewhere who thought that it was obvious that the president and vice president were included. But if no one outside of the, House of Representatives chamber engaging in, political speech making would have thought that, then
Okay.
what does it matter?
I have a question. Okay.
Sure, yeah.
Yeah. So, we've slipped into this too, and it tends to when I see this covered in the news with lawyers or just pundits, everyone is kind of speculating as to what's Gorsuch going to do, given that they cite Gorsuch in this Colorado
Yes.
Supreme Court, which I just that's so good. It's so good.
Mhm.
It just makes my toes tingle. What's Thomas going to do? Whatever. But what do you think that the more left or the more how do you want to say progressive, or what's the correct term
Yeah.
for the division on the court?
I mean, normally they're just called the liberal justices.
Okay, what do you think the liberal justices are going to do? We're all so we're all really focused on the conservatives, but they have opinions too. They have they're going to go down in history on this, so I'm curious.
I mean, I would say it's hard to know about Ketanji Brown Jackson just because of how new she is.
Mm-hmm.
My understanding, though, from what little I've seen and read by her, um, is that she is generally quite meticulous in her writing. I don't expect her to make some of like the shoddy mistakes we see out of
Kavanaugh.
Alito
Oh
or
yeah,
Kavanaugh.
yeah.
Yeah. Um, but I also don't expect it to be. She feels like of the three, the most who is a bog standard lawyer.
Okay.
Reading Kagan feels like reading an academic, and she was an academic. She was never a judge.
Okay. Right.
So in terms of which one I think would be probably personally the best to rely on going forward, if you wanted to make any sort of like useful legal arguments, I'm particularly anticipating whatever Kagan writes.
Okay.
Sotomayor is
Mm-hmm.
much more intentionally modeling herself in the style of Scalia, right? So her stuff isn't the most academic, but it's witty, it's engaging, it's meant to be emotionally evocative.
Yeah.
Sort of I know I'm not going to win this battle, but maybe enough law school students will read and agree with me that I'll win 50 years from now.
Right.
My assumption, I have to imagine that most of them are going to come down on the side of the Colorado court.
Yeah.
They might come down basically saying, look, we agree with your reasoning, but this should have been, say, done in a federal court. Because certainly one of the issues would be, like was brought up, that sort of patchwork style.
Mm-hmm.
And say, like, well, look, this is a federal election. We can't have someone elected who was on only half the ballots in just the most strategic states because no one can agree on what it means to commit an insurrection. So one thing I think would be an interesting solution would be to basically say, well, look, you can absolutely litigate this, and yeah, random citizens might have standing to sue, just like political parties or PACs or any other relevant stakeholder. But this is a federal question, and it should go through the federal courts. You shouldn't be leaving it to the secretaries of different states to make that decision. In part because we've discussed how things are sort of a Lovecraftian mess already in our system.
Mm-hmm.
Pennsylvania, for example, where I live and practice, does not have a Secretary of State with that power. You can only get that sort of election remedy through our courts.
Right. Yeah.
And weirdly enough, the court that has original jurisdiction over that is one of our intermediate courts. And I said one because we have two of them. Like, the whole system's a mess.
Yeah, I mean, it's let 50 flowers grow, right? Like let every state figure it out because local control. Well, I mean, does this feel a bit like a constitutional crisis? Because whenever I talk about it, it reminds me this is kind of a constitutional crisis.
I think it has to be. I mean, look, the justices are very good at dodging and minimizing big issues whenever they get the chance, right? I mean, there's literally a term for it. It's constitutional avoidance, right? Literally talk about the constitutional issue only as an absolute last resort. But I don't know really how else you solve this without creating at least a more uniform national standard,
Mm-hmm.
or siding more or less on no, this is straight, even federal elections, it's all up to local control, and it's kind of not this court's place to do anything more than be a very fancy dictionary, which would seem to me a waste and very chaotic. But the court's done stuff like that before
Well,
and
yeah,
pulled it back.
well, look how they messed. Was it Section 5 of the Civil Rights Act? And it's like,
Oh,
Congress you're just supposed to write this up, and you haven't. And we're just, we don't. You're just gonna go. Oh, that's gone. You
yeah.
know, and the chaos that ensued. But, yeah, it's quite interesting. I I think a lot of people assume that when the Supreme Court decision comes down, that's going to kind of be the end of it. And you're the first person who said, "Yeah, this just might be round one."
Oh yeah.
And
Yeah, no, I I hold no illusions that this is going to be over. I wish it was. It's not good for my blood pressure. But
but that makes so much sense because you're right. This is a really complicated issue, and the remedy, the Supreme Court is quite unlikely to just come up with a big decision that's going to set a new precedent or a new system for like interpreting this that's going to apply to all 50 states, and they're all going to have to like modify their. Like, that seems like too sweeping a thing based on what you're saying about the court's self-imposed conservative small c decision preferences,
yes.
rather than being the activist judges that they all condemn when they're at the Federalist Society dinners.
Um, and yeah, I mean that's the thing when you, in terms of the say like the reasonableness of the conservative justices. I do think the two that are probably most principled and most restrained judicially are Gorsuch and Roberts. Roberts famously has an almost pathological obsession with the court's reputation and the deciding only the narrowest issue possible so as to
Mm,
not step out of line and cause too much of a fuss. Um, and Gorsuch, I feel like, sort of gets there just by necessity of only limiting himself to the text wherever
mm,
possible.
yeah.
He tends not to go too far afield, and so I kind of think even if you get a 6-3 outcome, there's a possibility we don't get a full majority opinion. That we get
Mm-hmm.
either a plurality opinion or we get a majority opinion for only some questions and not others.
Mm-hmm.
Um, the prototypical example for that I always think of is Planned Parenthood v. Casey, which the Dobbs decision
Yes.
overruled. Um, it had the majority opinion was authored by 3 different justices, and it was literally like section by section. It was like, okay, sections 1 and 2 are the majority, and then an opinion of the court on sections 3A, C, and D. 3B is actually only one justice, like just, Souter wrote that one. And then section 4 is once again the majority opinion of the court. It was an absolute mess.
Yeah.
And so for really big issues, I
Yeah.
often think, well, that we might have that, especially since I
Mm-hmm.
don't know if we have the court. So like we had in US v. Nixon when they were deciding Nixon's tapes, it was the active decision of the Supreme Court Chief Justice. Then he says, we have to have a majority opinion. This is not a majority opinion, a unanimous opinion.
Mm.
This is too big of an issue and too big of a test of the court's power and legitimacy for us to be fractured.
Mm.
So if you go
Mm.
and look up the history
Yeah.
of that, it's like 6 justices each wrote their own section of the majority opinion. And it's all like Frankenstein together because
Yeah.
they were like, we don't care. We need to have everyone on board.
Hmm.
I don't know if this is that court.
Yeah, that seems a big ask of this
Yeah.
court. Any kind of unanimity.
Especially since I believe it was that Chief Justice Berger, there might be a different one, when asked what his greatest skill was on the court, said, I can count to 5. Um,
Yeah.
again, while it is a lot of ideology and rarefied law, a lot of it is also just practical horse trading behind
Mm-hmm.
closed doors. You get my vote if you insert this footnote right here. Brennan was famous for doing that. He would go, "Oh yeah, no, I don't want to write the opinion or anything like that. You got my vote. Just in your opinion, insert this footnote here." And then 3 years later, he'd be able to go, "As we noted in our
Right.
presidential opinion in this
Mm-hmm.
footnote."
Mm-hmm. Wow, that's long game.
Yeah.
That's a long
So
game. Wow.
they are not unsophisticated actors.
Clearly not. Clearly not. All right. So, what else
Yeah.
did you want to, or should we talk about that we haven't, or that I didn't think to bring up on this topic?
Um, I will. The only thing I would mention is we do have some lower court federal decisions, both from the Civil War, but also from this insurrection.
Right. The convictions that have populated our federal prison system.
Yes. Um, and so, for example, we have a North Dakota case that is just from 2022. I'm sorry, not North Dakota, Northern District of Georgia. Um, that yeah, it's 2022, but it addresses the Amnesty Act of 1872.
Well, I mean, who isn't going to cite the Amnesty Act of 1872? I mean,
Of course.
like I've got it on my shelf right next to me.
But the idea is like, does it remove 14th Amendment disability based off of someone who has, like, if you were already disqualified at the time the act passed, or would allow you to be pardoned, quote unquote, for that offense going forward. And in that case, I believe the federal court and the Northern District said no, it doesn't. It acted only retroactively. It applied to the people who were alive and had that disability in 1872. You, random person now in 2022, cannot invoke that to get around 14th Amendment disqualification.
But nice try.
Yes.
You did your
Yes,
research.
absolutely a bonus to whatever lawyer came up with that absolutely wild theory, but no.
That's definitely throwing spaghetti at the wall and hoping something sticks defense.
Yes. But yeah, so we'll see. I don't know how long it's going to take to play out, especially since it seems like the Republican primary is functionally over
Yeah.
at this point. Um, we might start seeing more states take up litigation. I know there's still pending litigation in Illinois. I presume Pennsylvania is going to have litigation at some point.
I think there's a case up in Wisconsin too, but I haven't heard anything on, I think they're also waiting. So yeah, I think there's a couple open cases that haven't been decided and a handful that have put him on the ballot,
Yeah.
and then two that haven't.
Yeah.
So
especially since Pennsylvania was a swing state and we just had elections for our judges because we elect our judiciary here.
Yeah, we do in Wisconsin too.
Yeah.
So
I'm not sure how good of an idea that is, but
my undergraduate con law course was taught by our county, like one of the county judges.
Oh.
Which was cool.
Okay. Yeah, that is kind of cool.
Yeah. It was like an evening class, like Wednesday 6 to 9, kind of thing. But
that would make sense.
Yeah. But that is where I got my grounding in con law. So
Okay.
yeah, so I think
You think of anything else?
No, but this is such a good conversation.
Yeah. And I mean, if new developments
Yes,
come up, I'm always happy to chat. Or
if
stuff's behind a paywall, I have
access.
I can grab a lot of that stuff because I get it for work.
Excellent. Yeah, I think it would be fantastic. I don't know if you would come on to the happy hour too, maybe when it was a big decision.
Absolutely.
Okay, so I'll let Kevin know as well. But sometimes I might just want you to myself, so we'll have to see.
Okay.
But
the only thing I'll qualify it with, and I don't know exactly how that translates to EU time zones, is but 8:30 to 4:30 local time, Monday to Friday is when I have my job.
Oh, okay. Yeah,
Um,
we normally like the happy hour normally starts like an hour ago, like when we started,
okay.
or now. And if you had like something to do, at a certain point, you could always just duck out as well. So because this, they're going to have the arguments, so that's a
Hmm.
possibility for us to chat again once we see the coverage of what the actual lawyers argue in front of the court, and also what questions the court asks, because that will
Yes.
be very revealing if I right.
Yeah.
And then of course when the decision comes out, well, the first decision, and then the fallout, and then the second case, and the second oral arguments. The second, no, this could go all the way through November if Trump
Oh yeah.
lasts that long. So
I'm definitely looking forward to it. Especially since, in all arguments, if there's one thing that I have definitely learned about Ketanji Brown Jackson is I am never left in doubt about what her position is when she asks a question. She's always very overt, going like, "Okay, well,
hmm
here's why I think what you just said was stupid." Um,
Which is, when people do like, yeah, judge watching, that's the easiest one. Yes.
oh
To
yeah,
know. Okay. Yes, no, definitely. And we have figured out, well, I've got my tech problems on my OBS fixed, also my YouTube
yeah,
problem fixed. We've got our time zones sorted.
all figured
So
out.
next, yeah, we're ready now. We're good. We've done a
Yes,
few false starts, but now we know when to start and how it all works. So yeah, I would love to have you back. Thank you so much for your time and sharing your expertise and answering these like niggly questions that were in the back of my head going, but, how is due process a requirement that they're saying? Because, yeah, and then you're like, oh, elector stuff. I'm like, oh, okay, well, that makes
yeah,
sense. So thank you so very much.
absolutely.
Is there anything you want to shout out? Do you have like a Blue Sky account or an Instagram or a Facebook, or I don't know if you're still on
No,
X or no? It's all
no, I
good.
don't have any of that
Okay.
stuff. Yeah, I'm just in chat.
Okay. Very good. All right. Well, until we talk again, stick around after I say goodbye. We're gonna
Absolutely.
okay. But from the people in the chat, thank you so much for stopping by and watching. I hope you got as much out of this as I did, because I had a really fun time. And I already have a pre-recorded chapter 2 of Data Feminism up, scheduled to be released tomorrow at 2 in lieu of my live stream. So go watch that. And I've been Christy. You've been awesome. Have a great day, wherever
Thank
it
you.
is, whenever it is you are. You want to say goodbye, Marcus
Abs-
Drake?
Absolutely. I've loved being here. Thank you all so much. Have a good rest of your day.
And we're out. Bye, everyone.